Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Ram Avtar Mittal vs. Income Tax Officer, pronounced by Delhi Tribunal on the 29th of April 2026. The assessee, Ram Avtar Mittal, an individual from Meerut, filed appeals against orders of the CIT, 3, Noida for AYs 2017-18, 2018-19, and 2020-21. The lead case is number 6052, Del. 2025 for assessment year 2017-18. Reassessment was triggered by information from DDIT, ADIT, investigation, 2, Chandigarh, alleging an unexplained cash payment of Rs 75 lakh for purchase of a movable property. The AO reopened assessment under Section 148, relying on third-party statements and an Excel sheet described as a dumb document, found during a search on a third party. The assessee had originally disclosed a payment of Rs 33 lakh through banking channels, which was not disputed. During reassessment proceedings, the assessee specifically requested an opportunity to cross-examine the persons whose statements were used to draw adverse inferences. This request was denied by the AO. The CIT, upheld the addition, leading to the appeal before the ITAT. The assessee raised multiple grounds, including illegality of reopening, lack of jurisdiction, and violation of natural justice due to denial of cross-examination. Ground number 7 specifically challenged the addition based on material collected behind the assessee's back and denial of cross-examination. The ITAT observed that the entire addition of Rs 75 lakh was made purely on the basis of statements of third parties. The assessee had made a specific request for cross-examination, but this was not extended. The tribunal stated that, not providing opportunity of cross-examination is against the principles of natural justice. The ITAT relied on the Supreme Court's decision in Andaman Timber Industries vs. CCE, 2015, 62 Taxman.com 3, Supreme Court. In that case, the Supreme Court held that not allowing an assessee to cross-examine witnesses whose statements form the basis of an adverse order is a serious flaw which makes the order nullity. Following the Supreme Court precedent, the ITAT concluded that the reassessment was beyond jurisdiction and bad in law. Since the addition was based solely on third-party statements and the assessee was denied the opportunity to test their veracity through cross-examination, the assessment was quashed. The tribunal did not adjudicate on the other grounds, such as validity of reopening under Section 148 or sanction under Section 151, as they became academic once the assessment was held to be void due to violation of natural justice. The tribunal noted that the facts for AYs 2018-19 and 2020-21 were exactly similar to assessment year 2017-18. Therefore, the findings in the lead case were applied mutatis mutandis to the other two appeals, and all three were allowed. The ITAT's decision reinforces that substantive additions cannot be sustained if procedural safeguards of natural justice are violated. The revenue cannot rely on unverified third-party statements without giving the assessee a fair chance to rebut them through cross-examination. Question: what was the main legal issue in the Ram Avtar Mittal case? Answer: the main issue was whether the reassessment order under Section 148 was valid when the assessing officer made additions based on third-party statements but denied the assessee the opportunity to cross-examine those witnesses, thereby violating principles of natural justice. Question: which Supreme Court case did the ITAT rely on to quash the assessment? Answer: the ITAT relied on the Supreme Court's decision in Andaman Timber Industries vs. CCE, 2015, 62 Taxman.com 3, Supreme Court, which held that denying cross-examination of witnesses whose statements are used against an assessee makes the order a nullity. Question: did the ITAT decide on the other grounds raised by the assessee, such as the validity of reopening under Section 148? Answer: no. The ITAT specifically stated that since the assessment was quashed on the legal issue of violation of natural justice, ground number 7, the other grounds became academic and were not adjudicated. Question: what was the nature of the addition made by the assessing officer? Answer: the addition was Rs 75 lakh under Section 69A of the Income Tax Act, on account of an alleged unexplained cash payment for the purchase of a movable property. The assessee had already disclosed a payment of Rs 33 lakh through banking channels. Question: what is the practical implication of this order for taxpayers? Answer: this order reinforces that taxpayers have a fundamental right to cross-examine any witness whose statement is used against them. If the revenue fails to provide this opportunity despite a specific request, the resulting assessment order can be challenged and quashed on the ground of violation of natural justice. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, taxpundit.org. If you have any questions, feel free to write to us at taxpundit@taxpundit.org, or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.